Hello everyone, my name is Bhuvneshwari Goswami and I'm a student member of Madhyasthta, the ADR Cell of Bharati Vidyapeeth University's New Law College, Pune. New Law College, Pune combines genuine excellence and wonderful diversity on a scale that is unmatched anywhere. No law school has done more to shape law or legal education like what New Law College has done. The unique strength of our institution is that it brings together from around the world so many exceptionally talented people of different backgrounds, experiences, interests, ambitions, approaches, methodologies, and perspectives. Whoever you are, whatever you do, however you do it, New Law College Pune is a place where you can thrive in it. Madhyasthta, the ADR Cell, is a student-driven cell established by New Law College Pune a year ago. Since its inception, the cell has tirelessly put in efforts to bring to its students seminars, national panel discussions, Oxford-style debates, various competition, publishing journals, and many more other ventures which would enable them to garner information about alternative dispute resolution practices. All thanks to our principal in charge, Dr. Bhakshi Deshpande ma'am, who has supported us throughout the initiative, and Mr. Shivangi Sinha, our faculty coordinator, who has been a constant source of guidance and support. Recently, the cell launched its one-of-a-kind venture entitled Global Initiative for Alternative Dispute Resolution Awareness, or as it is well known amongst the student community, GIADRA, an oracle for ADR. Through this venture, Madhyasthta aims at creating a single platform that brings together ADR professionals across the globe to impart knowledge of ADR and make it more prevalent practice. Today, we have one such ADR professional, Mr. Aloysius Goh, who will be sharing his thoughts on international commercial mediation in Asia. He is currently the founder and chief executive officer at Sage Mediation and was previously working as a registrar and chief executive officer at Singapore International Mediation Center. We are indeed privileged and honored to have you amongst us, sir.
So the first question is, at which stage of conflict dispute can mediation be used?
The mediation can be used at any stage of the conflict. The question, however, is when is the best time for it to be used? And there is definitely a difference of opinion, and I guess that is a lot of it. Because mediation is so flexible, a lot of the suitability then depends on the nature of the parties and the dispute itself. I think where the matter is fairly straightforward, meaning it's primarily a dispute on facts, then I would always encourage parties try to go for mediation early. Get help. If you have tried to negotiate with the other parties twice and you find that there is no progress, and even worse, things are getting worse, people are getting more and more frustrated and angry, then call for help. Don't keep banging your head against the wall, choosing a path that you already know has not had good returns, and get the help early. But certainly there are cases where when people say that the mediation is not yet ripe. We don't fully understand what are the issues, where are the differences, what are we actually fighting about. And then in those cases, I would say, let the matter proceed a little bit more. Let both sides have more information to truly consider. It helps them to consider what are the possibilities to get the matter resolved. Then you can wait in legal terms to around discovery, just after discovery, basically when some of the key material evidence has already been exchanged. And that helps parties to come to a better formulation of what is a good way to get the matter resolved. But I mean, as a rule of thumb, I would always say try to go for mediation early before it has escalated beyond a certain point. Yeah.
Thank you so much, sir. So, as we know that there are a lot of commercial disputes which are, even arbitrable, it can be negotiated or can be mediated. So, what are the specific set of dispute which would be most beneficially would be resolved through the process of mediation? And what could be the advantage that mediation could hold over arbitration and negotiation as such when we're resolving such disputes?
Very good. So depending on the jurisdiction that you are in, in fact, because I've done a lot of international work and I've looked at different jurisdictions, historically, most jurisdictions start mediation with family matters as well as lower value civil claims. Of course, then if you are like India or even like Singapore, where mediation is slightly more mature as a dispute resolution form, and then you start seeing mediation being used for more complex commercial, multi-party, or even investor-state matters. There's a reason why it starts with family matters and small claims matters. And if you look at the profile of family disputes and you use that as a guide, basically disputes that should be mediated rather than arbitrated or litigated are where parties are likely to benefit the most from non-financial solutions. They are likely to be in a situation that is unique, that legal precedent and legislation cannot provide the best customized solution because every family and every family circumstance is slightly unique. And if I and the last condition is speed, because they are living in a lot of discomfort, a lot of pain, as long as the matter is not resolved. And if you use a legal process, it's very protracted. It will then aggravate the pain for all the parties, all the stakeholders in the dispute. So you need something fast, you need something that is creative, and you need something which is going to be reasonably affordable because the money can be better used elsewhere. And if you look at this kind of conditions, I have found recently because of COVID, that I am helping a lot of startups and a lot of small companies to deal with their commercial disputes. One, because financially they cannot afford to spend that kind of money in a long drawn legal battle. Arbitrations are very expensive in Singapore, arguably more expensive than litigating. They are often involved in intellectual property related matters, because they are startups. They have a new creative product, but they can't afford to fight against their bigger suppliers or their bigger clients. They will lose that battle, but they have a valuable product right there. And for them as a startup, cultivating a strong relationship is actually very important. So you don't want to get that kind of reputation that says, you are being sued or you like to sue others. You like to cultivate that reputation that says, look, I value my partners, and I want to use a process that shows I value my partners, that shows that I'm trying to create something long term, that I'm trying to build a community. So when those matters are important to the parties, you definitely want to choose mediation over arbitration or litigation. Yeah.
Thank you, sir. Sir, the question is, for a lawyer who has been practicing for many years, but he has just got his first mediation case, what should he do? Like, what is the procedure and all?
Call me. That's the first thing you should do. No, I'll call you. Right? Okay. No. So if well, and maybe I'm only half kidding. Look, if he doesn't know what to do in this day and age, many things he can do. He go on the internet. There's actually a lot of information about mediation. I know in the different India states, because I've been very active with my friends in India. There are very good mediators in India. So ask around, get a mediator to even if it is not to mediate, but to walk him through what the process is likely to look like. Because you tell me this is his first case, he's never been for it. I think the mediator, there are a lot of good mediators who are prepared to give free advice, because it won't take very long. It'll take about an hour just to walk the lawyer through. Look, this is what the process is going to be like. This is what you need to prepare in terms of a statement for the mediator. What is the information that will be useful to the mediator? And this is what you should do when you meet with your client. Prepare him to speak, him or her to speak. Remind him that you are playing a supporting role as a lawyer, but you will work with him on a strategy to get a good outcome. What you shouldn't do as a lawyer when you get your first case is, number one, to think that you already know how to do everything. I think that kind of hubris when I meet with a lawyer who tells me he knows everything about mediation, that is the first sign that he knows nothing about mediation. The second thing that you don't want to do as a lawyer is to prepare for the mediation as if this is a litigation. Again, when I meet lawyers who cast the other side as an aggressor, as an enemy to conquer and to beat, that is another telltale sign that you might not be fully ready. It might be a case where you are projecting. It's because you want to play the enemy and the warrior. So I'm not asking lawyers to be naive here and to go in, all prepared to be collaborative, but the mindset is important. So when you get a case, first thing you do is to keep in mind that this is a collaborative process. Adjust your mindset. If you don't know enough about the process, seek help. There is free help on the internet. Mediators are prepared. If it's just for an hour, I am prepared to talk. I'm sure many mediators in India are prepared to talk. And then walk it through slowly. Yeah.
Thank you so much, sir. So as we know that the fundamental of mediation is that a mediator would not be giving any advice or like influencing the negotiations of the parties as such, and he just there to facilitate the conversation between the parties. But there are times when parties do need advice, whether legal advice or financial advice, or there are times when parties are not well equipped with the commercial laws as such, and mediator could at that point intervene and give advice. So but since it's a mediation and he's in a dicey position where he could not speak much when it comes to advice, so what, according to you, should be the ideal approach that a mediator should be having for the same?
This is a very big debate, I know, in India. This whole notion that the mediator should completely stay away from being evaluative, from playing the role of a de facto judge, a pseudo judge, as when you are mediating. And yes, I agree that the mediator should not become a pretend judge, or in some cases, parties tell me the mediator really plays the role of a judge, right? And so let's be clear, I don't encourage that. But that said, you are absolutely right. A lot of parties come because they trust the mediator. And even if the mediator thinks that, I'm here as an equal, I'm not a judge, because of the Asian society, perhaps, parties do look up to the mediator for some kind of help, some kind of guidance. And definitely for a start, the mediator is there to provide procedural guidance. We are there to help the parties to think through what they need to think through in order to come to a good decision. And that to me is guidance. When you come to me with a commercial dispute, and I am trying to facilitate a solution, and if one side can't afford to pay a huge lump sum to the other side, but I think it is natural that I intervene as a mediator to say, well, Ansh, if if he can't pay you in a lump sum, are you prepared to accept installments? And for me to then go back to Bhuvanesh and say, Bhuvanesh, I think I can persuade Ansh to agree to installments, but do you understand what installments means? Do you understand what a default clause means? That if you miss any of the payments of the installments, the whole sum becomes due. And I think the mediator must be prepared to offer this kind of guidance and must be prepared to ask some of these questions. Even he cannot be so overly cautious that he just sits back and says, no, these are legal terms. Let's let the parties figure it out themselves. Even though I from doing 200, 300 commercial cases, I know that installments will work. But the moment Ansh says, no, I refuse, it must be a lump sum, I don't try to seed that idea of installment payments, because that is, you are using the idea of facilitation to excuse your own incompetence. A competent facilitative mediator borrows from his own experience, but he is definitely careful not to impose his views of right or wrong. It is one thing to sit and tell Ansh, have you considered, if we cannot get this matter resolved because you don't want to accept a lump sum payment, what this means for your business? Have you thought of how much more time you need to spend in a legal battle to get back that money because you don't want to accept a lump sum? Versus, Ansh, you do know that if you don't accept a lump sum, it's 2 years in court because Bhuvanesh is going to appeal. You're going to spend about $1 million US, and chances are, even if you win, you lose. So why don't you just take the lump sum settlement now, Ansh? Because I'm telling you, my brother judges in court will decide like me. And that registrar, I know her very well. If you can't settle it and you have appeared before me, and she finds out, she will scold you. So I don't agree with the second approach, but the first approach, I think, is something which facilitative mediators should be prepared to do. Yeah, but it's essentially doing the same thing, different way. Yeah.
So that was a great insight. And the next question is, if communication has been difficult, what can you do differently that is realistic as well as achievable in the case of customer lawsuit for a breach of warranty?
Again, first thing is call a mediator. No, well, there are many techniques to manage disputants who have suddenly become very, very emotional. And I think the first thing is to recognize that when people express frustration and express anger, it is philosophically and psychologically because they feel that they have been unfairly treated. They feel that they are not being heard. They feel that they are not being able to bring their point across to the person who is supposed to be listening. So it might be a case, they might be feeling this way because the response that they are getting to the message that they are sending is not the response that they expected. As a mediator, we are trained to use our tone and body language to give that initial acknowledgement of the message. And I think that is important. It is important to use non-verbals to show that, look, I am listening. Question mark that people have been asking me is that, look, Aloysius, thanks to COVID, everything now has to happen over Zoom, and how do we use non-verbals? And it's a question that flabbergasts me, because it's a case where, look, honestly, right now I'm seeing Ansh's face closer than I would if we were here in person. And I'm sure it's the same the other way around, because with Zoom, we actually get to focus a lot on the facial expressions of the different parties. With Zoom, you can see the background of where I am. I can see the background of where you are. I have looked very into people's homes during my mediation, and I'm like, look, because of COVID, I've actually gotten to know a lot of people more intimately than ever before. Non-verbals exist, right? And so you need to pay attention to the non-verbals, even if you're using Zoom. And to manage consumers who are unhappy over warranties and all. I mean, what is at the heart of it? We need to look at what are they truly after. There are definitely what I call rogue consumers. You know, people who abuse the product and then try to use the warranty to get a new one back. And I'm sorry, rogue consumers, you might not like to hear this. I think you're behaving like a rogue, and I've got no sympathy. You know, if you are a rogue consumer and you are trying to abuse the goodwill of people who work hard to sell you a good product, you are not going to get your way, right? But if you've got a genuine grievance, this is truly a lemon that you have bought, then if the manufacturer is not managing this well, it could be because he or she, basically the call center, has not done enough to manage that emotions. So manage the emotions well first, let the consumer calm down, ask your questions in a different way, and show sincerity. Try to make your way down to truly understand the circumstance of the client. And I'll give you an example. And this, though this is a very different example from a consumer warranty case, but it was very different. I was dealing with a medical case, and the person kept complaining for a long time about the treatment and the response that he got from the doctors. And I found out later on, because I took over the management of the complaint, and the first thing I did when I found that this case has been going on in the system for 3 years, this poor patient has been complaining for 3 years, right? And the hospital has been responding to him, but couldn't close the case. The first thing I did was to visit him in his home. And that closed the case. And you know why? Because he's a cripple. It was very hard for him to get out of his house to go and collect the medicines and the remedies that the doctors kept saying that will help his condition. And the doctors and the nurses, because the case took so long, the doctors and nurses who were managing this later on had forgotten in the case note that he's a cripple. And they failed to show empathy to this condition. So there are always things in the background. And I think if we are trying to resolve this dispute, we need to try and be sensitive to the full circumstance of both sides, and that will help us to resolve the dispute.
Yes, sir, indeed. Thank you so much, sir. So my next question is that since the pandemic time is going on and physical mediations are not that much possible, and somewhere or the other we are still relying on the technology for having mediation or any sort of work as such which is going around the world. So how will the technological reliance amidst the pandemic affect the whole process of mediation? The specific emphasis on economically weak South Asian countries where most of the commercial contracts are based on the fiduciary relationships. So what do you think would be the outcome in such countries?
No, I think definitely you see it's because I have been doing a lot of work online, and I've met with different parties who have different qualities of access to high quality infrastructure. And certainly the disadvantaged communities do face that disadvantage if they don't have access to Wi-Fi. Of course, the reality when I looked at it is, unfortunately, many of this disadvantaged communities would also have been similarly disadvantaged in terms of physical travel. So it's not like this sudden digitization of mediation has greatly escalated their isolation. Their isolation was always there, right? And I'm not trying to make light of it. I'm trying to actually say this as this is a grave matter that I wish governments and even private individuals can do more to address, because this is something which cannot be left to governments alone. For a lot of the poor, definitely IT infrastructure is not great, but that is because the road infrastructure is also not great. The government, the people can't go in to lay the cables and to support, help them get access to justice. So that's it. The good news, however, is that I have found that the digitization of mediation and different legal services, thanks to COVID, has actually, on balance, helped a lot more people. I think that thanks to COVID, a lot of governments have now realized that we need to build this infrastructure, and we are, I think, globally, as one humanity, working to reach out to more disadvantaged communities, and we are also a lot more aware to the presence and the restrictions and the injustices that these disadvantaged communities are facing, and it's making us act with greater urgency, which is good. I think COVID has taught us that whatever happens to the least of us happens to all of us. And it's not just disease, it is injustice. I have had the privilege of working with different groups of mediators who have been actively trying to move out into these disadvantaged communities to help them resolve their disputes in person. They risk their lives doing so, and I commend them for doing it. I can't see an alternative at this moment to just courageous human spirit. But let's not underestimate the power of courageous human spirit.
Thank you, sir. Sir, the question is, next question. In commercial disputes, do we need lawyers in addition to mediators?
Well, we need good lawyers, as always. Good lawyers will always help. Of course, then the sensitive question is, what are good lawyers? Look, in a commercial dispute, I mean, like Singapore has come a long way, right? When I first started mediating, I think about 15 years ago, it was whenever lawyers were present, we just dread it, we just, oh no, I mean, can they come without lawyers? But it's changed. These days, I'm when parties tell me that they are appearing in person, I start to feel a bit uneasy. But that's because lawyers have started to be re-educated. They have recognized that, look, I'm not just here to be gladiator. That my client's best interest might not be best served for me winning his case in court. And I think when lawyers have shifted to this mindset, they are definitely an asset in the mediation. They should definitely be present. I have found that in cases where lawyers are present, they because they are slightly more detached than the parties themselves, they help to clarify the issues. Because of their training, the arguments are slightly more structured, slightly more coherent. They don't go through the same emotional trauma which the parties themselves have gone through. They help me to work with their clients, to check what I am saying and to validate what I'm doing as a mediator so that the client is confident. And when I can get the matter settled, again, because I don't claim to monopolize wisdom and skill, the lawyers then prove very, very useful to help me to draft a sustainable, high quality settlement agreement that is enforceable across borders. So I think definitely lawyers can be useful. Onus, however, is on clients to check in with the lawyers and have the lawyers choose lawyers who truly know the mediation process. I mean, if the lawyer is preparing you and advising you as if this is a litigation, advising you to use delay tactics, and advising you to use mediation to fish for information, those are bad lawyers. They are bad lawyers because there is a reason for them asking you to do that. Every time you use them to cause delay, every time you use them to fish for more information, they are charging you. They are charging you for everything that they write. So that is their tactic. And let me call it out. I think it's a bad tactic. And clients should not engage such lawyers. Yeah.
Thank you so much, sir. So as we know that many times, though mediation is a place where parties do come and have a fruitful conversation, resolve the dispute, but there are times when there is an interlocking of arguments comes up and parties at times are not able to resolve dispute and do get take a step back from mediation. So how can parties reach an effective agreement when every argument is coming to a fight? And what will be mediator's role in this, and how will he help to plan an effective mediation in cases of commercial dispute where usually there is a lot of heated arguments that we witness?
This comes back to your first question. When is the best time for a mediation? And it's exactly that. The moment you start a legal suit, the moment you start to fight, without a proper assistance, chances are a lot of history gets dug up. I'm right now trying to help friends, actually, old friends, to resolve a dispute. And it's very unfortunate because when you have been friends for so long and you start quarreling, typically there is a straw that breaks the camel's back. And instead of resolving the straw, which is actually extremely trivial, they start bringing things up that happened 6, 7, 8 years ago. And I'm like, wow, you've been keeping all this inside you for so long. So yeah, but now everything is going to come out. And it's the same when it's a corporate dispute. The moment you don't try to get the what caused the initial dispute to be resolved, things will escalate. So first thing, try to get the matter resolved early, before more interlocutories have been filed. The second thing is definitely, well, sometimes it is that complicated. Sometimes there are so many parties involved. And if you don't file the interlocutory, you can't get the information you need to prepare for the mediation. I get that. So let me not over poo-poo every single legal tactic, right? But I think where the mediator can play a part, and where lawyers and clients can use the mediator to play a part is when you see that things really look like they are escalating. That is the clearest symptom. When things are escalating, even though you don't want it to escalate, it is time to look for somebody who can give you a different perspective at resolving disputes. You might have chosen a lawyer who says that this is the only way, this is the best way, and he's probably a good lawyer. But it is certainly not a way you are comfortable with. Then it is time, speak to a mediator. Again, the free consultation is typically free. And at least realize that there are many roads to Rome. You don't need to resolve your conflict with only one way. And likelihood, when you start mediating, you can at least call for a stay of all the interlocutories, of any further hearings in court. And let's try to resolve some of those matters first, so that even if it still has to proceed to court, it proceeds to court only on the core matters, not on the frivolous matters that have been filed just to delay the case. Yeah.
Thank you so much, sir. Sir, like you said before, that some lawyers are there to fish around the information, additional information. So, sir, in ongoing commercial disputes pertaining to IPR, so the parties sit in different rooms, or they tend to sit together, or like they always try to meet together, or they meet separately, or perhaps in the separate room.
There is a style of mediation called shuttle mediation, where the parties are forever in separate rooms, and the mediator is in essence shuttling between the two rooms, or which depends on how many parties. Basically, every party is in one room, right? And he is the shuttle. I think that method is quite popular in America and some other jurisdictions. I must admit, it is not a method which I like. I personally like to have everyone start and end the mediation in the same room, because the aim of mediation is to arrive at a settlement agreement, and the settlement agreement is a contract. And the best way to enforce a contract is not by a Singapore convention or an up award with the New York Convention or a court order. The best way to get a contract enforced is when the parties trust each other. And if the parties don't ever have a chance to sit down and talk to each other, and start to restore some of that trust, some of that relationship, then there is a very high chance that your settlement agreement is going to be breached. So definitely I like parties to sit down, have that chance to look each other in the eyes, have that chance to convey, even if they have been hurt, what their respective actions have meant to each other. And have that chance when the mediation ends, hopefully with a good settlement, to convey to each other the joy and the happiness that says, we've put this to an end, let's get this behind us, let's look forward now. So I personally definitely like it that everyone has that time together, rather than just rely on the mediator. And let's not forget as well that, I mean, this is a very heavy responsibility on the mediator to make sure that he passes the message on accurately. And unfortunately, just as there are rogue consumers, I also know of rogue mediators. Sometimes deliberate, sometimes not. But if you don't communicate what you have heard from each party accurately, and it's difficult. You can't communicate the non-verbals accurately, right? So yeah, definitely joint sessions and some private sessions. I think that is a good mix and balance to get a lasting outcome for the parties.
Yes, sir, indeed. So joint sessions mediation obviously at times be fruitful, as there is a facilitation of conversation between the parties, and sole purpose of mediation is to sort out the things between the parties. So I completely agree with your point.
Yeah.
So, sir, as we know that there are times when parties do not agree for mediation. Even if a party is coming with a request to have a mediation, the responding party is not ready to go for a mediation, and the situation becomes pretty difficult when there are foreign parties involved in mediation. So how could we facilitate a mediation and make it possible when there are parties from different foreign nations are involved, and when there are n number of parties involved, like in the disputes of partnership firms as such? So how do we facilitate mediation in such cases?
Well, again, definitely. I mean, this is my specialty, both as a mediator and a trainer, right? So I mean, I would say sign up for the course. But if I do it in a nutshell, the the first advice is that recognize that there are differences. The second advice is recognize that whatever you diagnose is likely to be wrong. Whatever you stereotype is likely to be wrong, because there are no stereotypes. There is no such thing as a Japanese culture or a Singapore culture or an Indian culture. Every time I go to India, people laugh because, I mean, I'll say, look, tell me what is India culture. And then people from the north will tell me one thing, and people from the south will tell me one thing. And then I'll say, okay, fine. Then tell me what is Delhi culture. And Delhi alone is so hard to define. Same for Mumbai, Bangalore, Chennai, any of your big states. There is no such thing as one culture, right? But that said, is there going to be a difference between somebody who comes from Singapore and somebody who comes from America and Africa and the Middle East, Central Asia? Yes, there are differences, and I think then as a mediator or as a negotiator, the moment you are alert to this, that is and aware of this, that is step one. And step two, some of the categories that I use. Number one, what is the legal tradition? What is the business tradition there? And if you are using mediation, how is mediation practiced in the jurisdiction that you are in? One of the greatest discoveries that I encountered when I first started going into international mediation is that mediation means completely different things in different jurisdictions. Like you said, some parties like shuttle mediation, a lot of jurisdictions like evaluative mediation. So actually, India and Singapore are in the minority when we say we go facilitative. The majority of the world uses evaluative. The majority of the world is very comfortable with the judge and arbitrator of the same matter serving as the mediator. In Singapore, the default is no, the judge and arbitrator must be a separate person. It boils down to the cuisine, because my mediations typically take a full day, and I try to cater lunch and tea breaks. Am I careful enough to make sure the food is vegetarian? If I've got people who are Islamic, am I careful enough to make sure the food is halal? Am I careful to make sure that there's a separation between alcoholic and non-alcoholic beverages in the pantry? These little details matter when you are doing a cross-border dispute, and you need to be sensitive to them. Yeah.
Very well said, sir. Sir, does the mediator operate from an interest-based perspective in an employer-employee dispute?
For sure.
Employer and employee dispute.
Yeah. No. For sure. And again, this is because of COVID, one of the most common disputes that I'm dealing with now. For sure, we always operate from an interest-based dispute. Interest-based being when I get a claim, I will look beneath what you are asking for and ask myself and ask you during the mediation, what does getting this mean to you? What does getting this salary increment mean to you? What does getting this job title, this job scope mean to you? Why is it so important? And I ask this to both sides, because to the employee and the employer, that same salary increment, that same job designation means very, very different things. And until you as a mediator understand what this request, what these positions of the parties mean, it's very hard to broker a deal that both will be happy with.
Thank you, sir. So coming to the end of the session, the last question that I would like to know from your end, since you are working in Singapore as such. So as we know that Singapore has been a hub of ADR in Asian perspective. So how do you think Singapore would be, leading towards when it comes to commercial mediation as such, and what all development we could see in futures?
I mean, you guys flatter us. We are a very small country and a very small city. You know, even Delhi, even AP, and all of you on your own are about 4 or 5 times the size of Singapore. So thank you for saying that we're a hub. I mean, our government will be happy to hear that. I'm not confident enough, but I do recognize, however, so that don't look at it as false humility. I do recognize that we have been lucky to have had a Chief Justice and a Law Minister who have been extremely progressive on the ADR front. I think Singapore's advantage has been that we are heavily reliant on trade. Our domestic market is very, very small, and our government has therefore invested a lot, having the far-sightedness to build the infrastructure and the connections. So we are extremely connected to the rest of the world, which means that the little things that we do are being watched, are being copied, and that is where the impact of anything that happens in Singapore is amplified. In the coming years, I think the few things that Singapore will be leading on is that we are going to become a bit of a laboratory. You know, we are the world's laboratory when it comes to ADR, and I think that's what it is. We're not. I mean, maybe that's what makes us a hub, but we're going to be a laboratory so far as we are going to be showing the world how you enforce settlement agreements. We took the lead about 5 years ago when we launched the up process. So before the Singapore Convention existed, we told the world settlement agreements, mediated settlement agreements today can be enforced internationally by using the New York Convention, by using the mediation arbitration protocol. Again, we took the lead when the Mediation Convention was put out. We hosted it, we got it named after Singapore. More importantly, we are one of the first to have ratified it. So I think our courts are working very, very hard. We will likely be one of the first jurisdictions, I guess, to see the convention being put into force. And so again, that will be interesting to watch. We will be watched as well on virtual mediations because we have one of the highest levels of internet connectivity in the world. So people are watching how we use Zoom, how we use digital processes, how we use online mediation, online dispute resolution. And the last thing, which I am definitely very curious about, is I think it's about time, thankfully, that we start looking at what is truly going to be life in the new normal after COVID, because things are not going to go back to pre-COVID. We have now become a lot more comfortable with Zoom, and I think Singapore again will be that, because we have been one of the earliest out of the blocks to have kept cases away, and to have, at least for now, touching a lot of wood, avoided a second and third wave. So we are likely to be one of the first to go back to more in-person mediations. But I don't think it will be life as per normal. I think it will be, even not just for mediation, but for courts and for arbitration, we are going to be using a blended form, a hybrid form. Some key persons coming in person, non-essentials attending via Zoom. What is this going to look like? What is the process going to look like? How does submission of evidence, how does procedural justice become impacted in a blended form of a hearing? Again, I think this is where Singapore will take the lead. And it will be interesting because mediation, providing justice, litigation, providing fairness, this goes to the very heart of what it is to be human, what it means to be a community. And yeah, I know we are being watched, and I think this are the kind of narratives that you can expect out of Singapore in the next 2 to 3 years. Yeah.
Thank you so much, sir, for providing us with such an informative session. And I am sure by after looking and having a watch at this video, a lot of students will be benefiting and getting to know more about commercial mediation as such from your perspective. Thank you so much, sir, for agreeing for the session.
You are most welcome. You are most welcome. And thank you for having me, giving me the chance to do this. To those who actually end up watching this, thank you for watching it, right? But yeah, but again, thanks so much for having me for this session. Yeah.
Thank you, sir. Thank you.